Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name is Jim Santelle, and this is our weekly assessment, review, evaluation, and description of those major events, typically of the past week. And yes, it has been a week in the areas of law and government and the aspiration for justice in America. As always, I am delighted. I am honored that you have chosen to spend some of your weekend time with me in discussion about these very important issues to the lives of all Americans, to the livelihood of our nation and beyond. As always, as a part of that discussion, you are invited, and that can be accomplished by calling in to Max, my producer, or me at 855-752-4842. That number, once again, is 855-752-4842. Max always reminds me that you can also be a part of our discussion, our review of these important issues by dropping a comment, a question, an inquiry, an observation into the Civic Media box online. Be a part of our discussion this weekend. And yes, indeed, it is a weekend broadcast that is full of significant things in the areas of rule of law and justice, and especially government, virtually all of it, almost all of it, prompted by the actions of our new president, Donald Trump, who again was sworn in just under a week ago under the Capitol Rotunda Dome. And in the wake of that swearing in, almost immediately began to enter a great variety of executive orders, undertaking other actions, both directly from the White House and also from other agencies throughout Washington, D.C. Those kinds of actions are the things that animate our syllabus this weekend on Amicus, a law review. Let me tell you a bit about our agenda for the coming 2 hours. Initially, we're going to begin where we ended in our last broadcast, that is talking about an issue that has become even more significant since our last broadcast of the previous weekend, and that is where the guardrails, where the safety bumpers, if you will, with respect to the kinds of things that a president, any president, including this president, can do under the Constitution, under the laws of our nation. Where are the restrictions, the controls, the limits? What kinds of things can a president do? What kinds of things can a president not do under the rules and regulations of our nation? And we began last weekend to talk about the roles specifically of federal judges, emphasized this past week as at least one federal judge told us exactly how significant the involvement of federal judges can and should be in responding to the actions of presidents. We also began to talk about the role of United States attorneys throughout our nation, over 90 of those in the over 90 federal districts in our nation, including territories. We're going to talk about the roles of the U.S. attorneys, not only in taking direction from an attorney general, but if it happens in violation of the fundamental mores and methods by which the Department of Justice has acted, taking direction from the White House itself on how prosecutions should proceed in the various 92 districts in our nation. And that includes, of course, the two districts right here in the state of Wisconsin. There's an eastern district of Wisconsin, roughly the eastern third of the state geographically, and a western district of Wisconsin. U.S. attorneys in both of those districts, United States marshals also in both of those districts, likewise confirmed by the Senate upon nomination by a president. We're going to talk about the roles, the missions, the assignments of United States attorneys in the normal course, and the challenges that may be faced by the incoming U.S. attorneys under this administration. And then, much parallel to that, the role of trial judges, federal judges, state court judges in assessing the legitimacy of things that a president and indeed governor, other entities inside state, local, and federal government, the actions that they undertake. What is the role of the federal judiciary, the state judiciary, in terms of reviewing those kinds of actions and responding to them? We know, again, that just this past week, a federal judge on the west coast of our nation had some very strong words, some very strong reaction to one of the executive orders issued by our president in connection with the 14th Amendment. We'll talk all about that. We're also going to talk about some very strong words coming out of some federal district judges on the other side of the country, that is in Washington, D.C., as they were presented by this present administration through the Department of Justice with requests to dismiss some of the pending, not yet resolved cases coming out of the January 6th insurrection. We'll talk about what three of the federal judges had to say about those petitions coming from the U.S. Attorney's Office in the District of Columbia, coming from Maine Justice, asking once again that the judges dismiss those remaining cases that are still lingering out there. These are over and above, different from the pardons and computations also accomplished by the current president just this past week. And yes, indeed, we are necessarily going to be talking about those pardons. About 1,600 of them issued just this past week under the constitutional authority, as we have discussed in great detail in the past, of a president. Given that authority to do just that, to commute sentences as well, to reduce the sentences imposed against defendants, against people who are in prison or serving other components of their sentences. We'll talk about exactly what Donald Trump did, why those actions by him from the White House, arguably from the Department of Justice as well, are so incredibly important. And again, we're going to comment about the reactions of some federal judges to requests to dismiss the remaining cases as well. We'll talk about the significance of those. That is plainly at the top of many of the headlines to this day across America. And then necessarily, we're also going to talk about the 11th hour pardons issued by the former president. His name, of course, Joseph Biden. The things that he did in the last hours, candidly, the last minutes of his term in office. We'll talk about not only the prior pardons that he has issued throughout his term. Most recently, the flurry of them begun with the pardon of his own son, Hunter Biden, in late November of last year, continuing with large swaths of pardons as to various groups of people. We'll remind you of what those are, and then talk about these so-called preemptive pardons for people who have not committed crimes in America. Nonetheless, the president and others concerned about the possibility of investigations and prosecutions of them, and so granting to them preemptive pardons. Here is a pardon that should protect you from those investigations, certainly those prosecutions, should they come by this administration. We'll talk about the merits and, yes, indeed, the demerits of doing that, as you have heard me talk before about preemptive pardons, the difficulties with those as a purely legal and procedural matter, and, yes, indeed, like all criticism against present and former presidents, an appropriate response to what we should do in the midst of threats to former officials inside the government, even people who are presently in government, outside of government, private people, all kinds of people who might be facing unsupported and unwarranted investigations by our newly arriving Department of Justice. I'll offer to you what the remedy should have been. Yes, indeed, it involves lawyers. It involves attorneys stepping up and representing people unjustly investigated in America. All of that coming up, of course, in this, our first hour. We're necessarily also going to be talking about the United States Department of Justice itself, now under control of the new administration, the Trump administration, placing in the status of the present management of the Department of Justice, a fellow named Emile Beauvais, who just about 2 weeks ago was representing the now current president when he was appearing in a Manhattan courtroom to receive his sentence from Superior Court Judge Justice Juan Merchan. for those 34 counts of violations of New York law. Emile Beauvais, representing then private citizen Donald Trump in connection with that lawsuit, that prosecution against Donald Trump, finding that he was indeed guilty of violations of federal law, establishing a little more than 2 weeks ago that our current president was then and remains to this day a convicted felon. Emile Beauvais now taking his role inside the Department of Justice, no longer representing private citizen Donald Trump, no longer representing Donald Trump at all, but representing you, representing the United States population, representing the United States Department of Justice as the acting Deputy Attorney General. We'll talk about some major things that he and others have ordered just this past week. Those involve directions, again, to United States attorneys. That's why our discussion about what U.S. attorneys do and do not do is so important. United States attorneys telling them what they should do when it comes to local and state officials who may balk at the president's immigration policies, refusing or at least expressing disagreement with those policies. What is the directive from the top leader right now of the Department of Justice to what those U.S. attorneys should do? And the answer is investigate and perhaps prosecute them criminally for not falling in line. We'll talk about that amazing, stunning directive coming out of the Department of Justice. And we'll also talk about another component of the Department of Justice called the Civil Rights Division. We have talked a lot about that in prior broadcasts. Significant things, again, coming out of the U.S. Department of Justice just this past week. The Civil Rights Division, effectively no new cases being initiated in the present circumstances, shutting down review of consent decrees that were in place, about to be approved by judges around the country, but also others involved in police reform in America. We'll talk about the restrictions on the Civil Rights Division, the movement of many longtime and newer attorneys inside the Civil Rights Division out of their present enforcement responsibilities and into a new unit that is going to focus on investigating and prosecuting people from so-called sanctuary cities who likewise do not follow the dictates, the mandates of the president's directives when it comes to immigration policy. Lots of things, lots of very troubling things coming out of the U.S. Department of Justice that are also not completely unprecedented in terms of directives, but certainly contrary to the movement generally of the Department of Justice in recent years under all administrations, Republican and Democrat. We're also going to be talking, of course, about the Supreme Court and the things it did just this past week. All of that coming up on this edition of Amicus, a Law Review. Stay with us for that discussion. My name is Jim Santelle, and this is Amicus, a Law Review, our weekly weekend review of all things government, justice-related, court-related, prosecution-related, rule of law-related. Thank you for joining me this weekend for a discussion of many dizzying things coming out of the U.S. Department of Justice, coming out of the White House, coming out of Washington, D.C., including our United States Supreme Court just this past week. We will also talk, of course, about some of the, at least a couple of the oral arguments conducted by the Supreme Court just this past week. One of those having to do with excessive force and the mechanisms under which judges assess the propriety or impropriety of police in the marketplace. We'll also talk about some other cases pending in front of the Supreme Court, including one involving a money laundering statute, its revival, its effective resurrection of a money laundering statute that just happening this past week. Lots and lots of things to get to, including, as I promised initially, resumption of our discussion about guardrails and standards, those kinds of things that we should be able to rely upon in terms of institutional limitations and conditions, restrictions, and checks on the kinds of things that branches of government do. We know well that under the Constitution, this designed by James Madison and others, checks and balances across the board between the legislature and the executive branch and the judicial branch. And for the most part, those have worked throughout much, if not all, of our 238 years of existence. Some of that beginning to fray at the edges as we look more and more to things like the Supreme Court's decision of last July, effectively elevating the executive branch above the others in terms of its power and authority and its immunity from prosecution for crimes committed. All of those things implicated not only in the past, but now just this past week, as the current president, under his authority as the executive of our nation, executes the law, as we talked about before, arguably, depending upon your perspective, taking care under the constitutional language that the laws of our government, of our nation, be faithfully executed. All of those issues coming into play in the hours and days after Donald Trump's inauguration, including these many different executive orders. Most of them, not all of them, but most of them focusing upon immigration, ways big and small, all kinds of things that the president is doing in that area and others as well. We'll also talk, of course, about the executive order having to do with birthright citizenship. Under the 14th Amendment, we'll talk about what a federal court judge did just this past week in connection with that attempt to change the 14th Amendment to the Constitution of the United States of America. But before we get to all of that, let's talk about civics. Let's talk about the mechanisms that are out there that ensure that actions of the government generally, including presidents of the United States of America, including executive agencies and authorities, behave in a way that's consistent with the laws and with our Constitution. I have mentioned before that there are over 90, there are actually 93 U.S. attorneys nationwide. Also in our territories, there are 94 districts altogether in the United States of America. You can go onto the maps provided by the Department of Justice, provided by our courts, and see where all of those district courts are. They have together formulate also circuit courts. Those are the places where you go after you're dissatisfied, for example, with a decision by a district court, the trial court judges. Ultimately, from the circuit court, where do you go? Well, you may go to the United States Supreme Court if the Supreme Court decides to hear your case. I'll mention in the second hour that as of this weekend, the Supreme Court in this 2024-2025 term has decided to hear 59 cases altogether up to this point, probably more being added. In the midst of that process in the judicial system, what are the roles of judges? What are the roles of United States attorneys? Let's begin there. United States attorneys, of course, are appointed by presidents. And they, again, according to the Constitution, nominated by the president, subject to the advice and consent of the Senate. Yes, the advice and consent, the approval of a majority of the senators is necessary before a United States attorney in any of those 93 districts can take office. This process also applies, interestingly, somewhat anachronistically, to United States Marshals, who, again, the very first law enforcement agency way back in 1789 in our nation. Our founding fathers thought the United States attorneys, ultimately, the people responsible for putting the laws into effect in these districts, ultimately. But significantly, even before that, the government, the Congress saying U.S. Marshals should also be confirmed by the United States Senate. We saw just on Friday of this week that confirmation process when our incoming Secretary of Defense was confirmed by a narrow majority, a one-vote majority broken by, if you will, the president of the Senate. He is the vice president of the United States of America named J.D. Vance. That same process, that approval process by a majority of senators also applies to United States attorneys. Why? Why? Because those people, while they should be and have been, for the most part, with some notable exceptions, apolitical and nonpartisan, are responsible once again to the people of our nation. Their role is not to be beholden to the president. It's not to be beholden to some other authority, but beholden to the Constitution, to the rules and regulations. And how is that done? That is done by oversight. Absolutely, by an attorney general, by a deputy attorney general, by other people responsible for administering the laws, establishing policy inside the Department of Justice. And so I had the great honor to serve as the United States attorney, initially court appointed in an interim process between two administrations, ultimately presidentially appointed in the administration of Barack Obama. I had the great honor to serve in his administration. More significantly, my boss, Eric Holder, for most of my term as United States attorney in the Eastern District of Wisconsin, responsible for doing what? Responsible for enforcing the federal criminal and, yes, indeed, the civil laws in the eastern third, approximately, of the state of Wisconsin. The Western District also present here in our state, a separate U.S. attorney venued in Madison. I was venued, as I have been recently, all U.S. attorneys in Milwaukee. There's also a branch of the court and a branch of the U.S. Attorney's Office in Green Bay to provide what? Service and support and safety and security for all of the people of the Eastern District of Wisconsin, the Western District of Wisconsin, and yes, indeed, the 91 other districts around the nation, including the Northern District of Illinois, the Southern District of Florida, which we've talked about a lot, the District of Massachusetts, the District of Wyoming, districts in California. All of them have U.S. attorneys responsible for implementing in those particular areas the rules and regulations, the laws, the processes of our government. And so one of the things that we have talked about a lot on this broadcast and others of Civic Media, again, is the responsibility of those U.S. attorneys taking an oath upon Senate confirmation to uphold the Constitution of the United States of America. And that's where one of the first guardrails comes in. And we will see in the coming weeks the roles, the actions, the purposes, and the focus of U.S. attorneys now being nominated, ultimately, presumably being confirmed by the United States Senate, the so-called Trump nominees. We'll talk about the Trump nominees. We'll talk about the nominees and the U.S. attorneys who are going to be inhabiting those positions in this time when lots of things are going to be coming out of the White House, their roles and their missions, all of that coming up on Amicus, a law review. This is Amicus, a law review here on the broadcast stations of Civic Media. My name is Jim Santelle, your host of this hour and next hour as well, as we talk about some civics on our weekend broadcast, providing some context for the responses of our judiciary and, yes, of U.S. attorneys going forward in a time of change, undeniably. Some of it quite dramatic in terms of the way in which we understand our Constitution, and the laws of the United States of America. U.S. attorneys, again, these individuals nominated by the president, confirmed by the Senate, if at all, and responsible then during the term of the presidency for enforcing local laws. And by that, I mean the geographically local laws. The laws they're enforcing are federal laws, but they do that in the local environments in which they are venued. 93 of them throughout the United States of America, including our territories. And so one of the safeguards, one of the conditions upon unfettered action by a president, for example, even by others inside government, is the United States Attorney, the chief federal law enforcement officer for the particular district, responsible for every single day assessing and determining whether or not actions, proposed investigative actions, prosecutorial actions, reviewing decisions to present cases to grand juries, reviewing decisions to open files, which is a very important issue now, making decisions about how the office, the United States Attorney's Office, how other federal agencies who are indeed under his or her oversight as the chief federal law enforcement officer for the district, how are they going to cooperate? How are they going to behave consistent with the laws of our nation? A huge responsibility, and also responsibility once again to you, to ensure that all of that is done in a way that is consistent with the oath of office to support and uphold and defend the Constitution of the United States of America. And so the question comes, when a president, through the Department of Justice, or even worse, directs a United States attorney to open an investigation of an individual, for example, for whom there is not a scintilla of evidence, there's not a predicate for opening a file. And yes, indeed, you don't have a probable cause to open a file, but you've got to have some reason to believe that the target of your investigation, even the subject initially of your investigation, may have committed some crime. And absent that, it is inappropriate, it's unethical, it is illegal to open up a file on someone because you do not like them, because they are a political enemy or foe or rival. That is not only inconsistent with our Constitution, but it is contrary to the basic ways in which U.S. attorneys are obliged to work. And so we know in recent times that the president, now in his office in the White House, has threatened to lock up his political foes like Liz Cheney and Adam Kinzinger. He has talked about encouraging the Department of Justice and the FBI to go after his rivals. His picks for Attorney General, we know her name is Pam Bondi. For FBI Director, his name Kash Patel, have echoed those remarks. Patel's even compiled an enemies list, which includes Christopher Wray, the now recently departed head of the FBI, and retired General Mark Milley. People like that, many others on these lists. What happens if the president calls a United States attorney and asks that United States attorney in a particular district to open an investigation of any of those people without a predicate belief that there has been some criminal conduct? And I should mention, as an aside, that has also been the practice and the policy, for very good reasons, to insulate U.S. attorneys from the White House itself. And so all communications, if there are any from a White House to a U.S. attorney, should necessarily be directed through where? Through the U.S. Department of Justice and through the Deputy Attorney General, who would determine what the inquiry is and what the nature of the request or the demand is before sending it on to a U.S. attorney. That's been the process. We will see if that continues. We know that this president already in this week has directed U.S. attorneys to dismiss some of the remaining January 6 cases. Presumably, those are going through the U.S. Department of Justice. But that issue of process is also important here. The larger issue, of course, is what does one do as a United States attorney required to uphold and defend the Constitution and not open investigations absent there being a reason to do so? What does one do in that circumstances where the boss, the ultimate boss, the president of the United States of America, who has signed off on your appointment as U.S. attorney, and the attorney general also signing off on that certificate of appointment directs you to open an investigation. What does one do? That's the challenge coming in for U.S. attorneys, if indeed that happens, if indeed people like Pam Bondi and Kash Patel and even the current president make good, or at least try to make good, on their effort to investigate and arguably prosecute people who they do not support. And so one of the safeguards, one of the stopgaps on that is a United States attorney necessarily saying, Department of Justice, people in the Department of Justice, the Deputy Attorney General, and certainly the president himself, one day herself, there is not a basis for doing that. And saying no. That's important, frankly, inside any government office, local, federal, state offices. When you are directed to do something that you know is unconstitutional, the obligation of your oath is to decline to do so. And you've got one of three alternatives. Then you can say, I'm not going to do that. That's not consistent. When you say that, it's highly likely that because you are an at-will employee, U.S. attorneys are not civil servants. I was for about 24, 25 years a civil servant, not subject to firing. But U.S. attorneys are. They are appointees of the president, can be fired at will. And it's highly likely that a president who's dissatisfied with the actions or inactions of a United States attorney could simply say, I am terminating you for cause, not for cause. Those things can be done. Nothing wrong with that process, but it's one of the things that could happen to prevent that safeguard, that guardrail, if you will, from stopping an action by a president. A second thing, of course, the U.S. attorney can do, in addition to saying no, which probably leads to his or her firing, is to decline to do it. And to ensure that that office, the integrity of that office is maintained, it may well be that that U.S. attorney then needs to resign. We think very generally in history about times when U.S. attorneys, in particular an attorney general, remember Elliot Richardson way back in the early 1970s, 1972, 1973, when he was asked by President Richard Nixon directly to direct that the special prosecutor at that time in the Watergate matter be fired. And Elliot Richardson said no. He said, Mr. President, I'm not doing that. There's no basis to do it. And so Elliot Richardson was not terminated. He resigned, as did his deputy attorney general. Ultimately, the associate attorney general, Robert Bork, did what the president said he was requesting to be done. That's the process. But that is one of the safeguards, one of the guardrails along the way. Along the way, one of the things that U.S. attorneys necessarily do is to authorize investigations, including grand jury investigations. We've talked a lot about that other safeguard. These are 23 people called in. They're a unit of the court. And under that system, under our system, grand jurors called in from the public. They're other people in businesses across the ambit of activity in our nation. They're called in to decide whether there is probable cause to believe that indictments should issue. And I've said on this broadcast and others that my own great respect for and recollection of 30 years of grand jury practice is that grand jurors do not indict ham sandwiches, as is often bandied about, an inappropriate and very flip way of understanding what they do. In fact, they do listen to the evidence, and they are a secondary safeguard, a check against a U.S. attorney, against a Department of Justice, indeed against a president who wants to try to prosecute through an indictment an individual for whom there is no criminal charge legitimately presented. That's also a safeguard out there. Along the way, during the course of the pre-public investigation, there's also the role, of course, of federal judges. And we began to talk about that last weekend, too. What do federal judges do even before cases are indicted, if at all, by a federal grand jury? Federal judges are also responsible for, in many ways, approving of the pre-indictment investigative conduct and activities of U.S. attorneys and of FBI agents and DEA agents and Postal Service inspectors and all sorts of people out there who are seeking to investigate legitimate crimes. And so, for example, if a federal district court judge is asked to sign off on what we call sort of an eavesdropping warrant under Title III, those kinds of things called a wiretap, he or she will receive an application called an ex parte submission from prosecutors applying for that and establishing probable cause probable cause to believe that there's a basis for that, frankly, incredible intrusion into the privacy and security, if you will, of communications. Judges, before investigations, do those kinds of things, and they ask U.S. attorneys and they ask the investigators, what is the basis for our going forward to doing this? And if that probable cause is not there, the federal judges of our nation are obliged by their oaths of office to say no, to say, you know what, I'm not going to give you, Mr. Santelle, that application. I'm not going to approve that application. I'm not going to give you that warrant to search a home, to search a telephone, to do some other things that are part of your investigative work, pre-indictment, because there is no basis for doing that. And that certainly would include situations where there is not a clearly identified federal criminal statute that is identified, again, even before the case is indicted, if at all. Judges have huge responsibilities. The one that we sometimes hear about, of course, is the responsibility to review applications for searches of properties, sometimes businesses, sometimes homes. And on a fairly regular basis, when I presented those applications, judges would sometimes say, yes, it is all there. They would sometimes say, no, I don't think, Mr. Santelle, you have established here that there is probable cause. Either develop more or the answer will be no. And so there are decisions there that are made pre-indictment during the course of that investigation that are also checks, yes, indeed, upon U.S. attorneys, upon investigators, upon the Department of Justice. And that is done, again, in the interests of America. Along the way, one of the things that U.S. attorneys have the benefit of in that process is that federal judges have generally have a well-founded confidence. The Justice Department, especially in the wake of Watergate and other things, have some sense of confidence that these applications, the requests, have been reviewed at great levels. Most district judges believe that prosecutors appearing before them are acting with integrity, that their offices are not being manipulated to undermine those who may have challenged the current administration or its leader. They have to look at those things, but there's a presumption of legitimacy and of regularity in all of that. A judge can assume that a warrant application has gone through layers of approval within the Justice Department, even reaching, in some instances, the Assistant Attorney General in charge of the criminal division. That's an extremely high-ranking official inside the department. That judge could also be reasonably confident that very little, if anything, would be amiss by passing that process through those various approval levels, including senior department officials. The comments, again, by our current president and others about this notion that we may be going after political rivals would fall into the category of undermining those assumptions. And if indeed federal judges, if somehow these applications get beyond U.S. attorneys and go to federal judges now have responsibility, as they have always had, but especially now, to check to make sure that the reason for the investigation, for the prosecution is legitimate, that there is a there, that there is a federal statute or a series of statutes that have arguably maybe been broken and that justify warrant applications, the judges granting those orders to search homes, to search telephones, electronic devices, to establish Title III listening mechanisms, those kinds of things. All of that is also the appropriate role of federal judges. Many other ways in which judges, even before cases are indicted by a grand jury, if at all, are responsible for ensuring the legitimacy of what's going on. And even in the wake, if somehow beyond a U.S. attorney check, beyond an initial pre-indictment investigative check, somehow a grand jury issues indictments and goes ahead with a prosecution proposed by the Department of Justice, judges plainly in the post-indictment period also have an obligation to do what? To ensure that the process includes due process and equal protection, all those things we talk about inside the Constitution. They will entertain motions to dismiss, motions to challenge the search warrants that they themselves may have authorized. We'll talk more about the roles post-indictment of judges and talk about the importance of this process as we go forward under the brand new Trump administration and the safeguards that are inside the department, inside the judicial branch, here on Amicus, a law review. is Amicus, a law review. My name is Jim Santelle, your host for the remaining minutes of this first hour here on the broadcast stations of Civic Media. Also going into our second hour as we continue not only this extended civics lesson here on our broadcast this weekend, but also begin to talk about the applications of these fundamental principles to the news of this past week, including, yes, indeed, the challenge to Donald Trump's birthright citizenship order, the pardons of both this president and the prior president, things going on inside the Department of Justice involving commitments or lack of commitments to investigate and prosecute state and local authorities, a direct implication of what we've been talking about in terms of guardrails and safety nets when it comes to the conduct of a president, of the Department of Justice, of U.S. attorneys, of grand juries, and also, of course, of trial judges, both before indictment and after indictment. After a case has been indicted, if it meets and surpasses all of those thresholds, those checks and balances, and again, even inside the great majority of U.S. attorneys' offices nationwide, there is review, there's analysis of proposed indictments to grand juries. Usually memorandums are written identifying the bases for going ahead, the statutes invoked, the reasons why the facts support the presentation of an indictment to a grand jury. Grand jury, once again, an entity not of the Department of Justice, not of the executive branch, but of the other branch there involved, and that's the judicial branch. And so that process is also a safeguard inside the U.S. Attorney's Office. If somehow all of these cases go forward after having gotten a supervisory review, U.S. attorney review, grand jury imprimatur, they go before a federal district court judge in the public domain. Judges there again have great authority to do all kinds of things to check, frankly, the other branch of government, the executive branch, as it goes ahead. And that includes entertaining, maybe granting, most often not granting, but on a regular basis, at least reviewing challenges to, for example, search warrants that were conducted in the pre-indictment stage. Was this legitimate? Was there probable cause? Was the grand jury process somehow tainted in some way? Was the process by which the search warrant was executed improper, justifying some remedial action by a district court judge? Is the indictment itself legitimate? Not only in terms of its terms, does it set forth allegations that are credible under the statute that's invoked? Are there reasons why it should be either reduced in size, dismissed entirely? Again, the great majority of those motions presented by legitimate and authorized and appropriate to our system defense attorneys. That is a part of our process to ensure a proper and complete defense of defendants. Along the way, one of the things that can be presented, for example, is a selective prosecution motion alleging that criminal charges were brought for reasons forbidden by the Constitution, not contemplated by all this process. Defendant has the obligation there to prove that he was singled out for prosecution when others who were similarly situated, for example, were not. And the prosecution was therefore based upon an impermissible reason. Could be race, could be religion, could be politics. A selective prosecution motion. We know well, for example, that Hunter Biden brought one of those. His motion to dismiss his gun case on selective prosecution grounds failed. It was not granted. It's a high standard. But those kinds of things can and should be undertaken by judges. They should entertain those motions as they pursue their own oversight of the cases, plainly to trial and to sentencing. And again, at the appellate level, as we've already talked, even this weekend, at the appellate court level, the circuit court level, judges have obligations to review what has happened at the lower court levels. Huge amounts of checks and balances out there beyond the White House, beyond the Department of Justice, to ensure that the checks and balances of our system are in place and are properly regarded. All of that a part of our system. And although it's not a check and balance that comes out of the investigative and prosecution stage and process that we're talking about principally, we saw an example of that. A federal district court judge just this past week in Seattle, looking not at a prosecution coming out of the Department of Justice, but looking rather at one of these many, many executive orders issued by the President of the United States of America. This one having to do, you know it well, it's the 14th Amendment. Basically, the president announcing by virtue of his pen one of several orders issued, and again, the opening days of his presidency, that the 14th Amendment, at least the first sentence of it, no longer means what it says and says what it means, declaring that children born in the United States to undocumented immigrants after February 19th would no longer be treated as citizens. The order also extends to babies born to mothers who are in the country legally but temporarily, such as tourists, university students, or temporary workers if the father is a non-citizen. Basically, this is the birthright citizenship attack. This is the attempt to change the Constitution. And indeed, immediately after the president executed that, a federal judge, another branch of government, entertained an action by a number of different attorneys general, many lawsuits across the country, which continue to this day, attacking that executive order. And the judge, he's a federal district court judge in Washington state. His name is John Cohenour, Coughnor. He looked at this, and in 25 minutes, he said this is blatantly unconstitutional. He said, frankly, challenging the lawyers now in the Department of Justice who are seeking to enforce what the president had done. He said, I have difficulty understanding how a member of the bar would state unequivocally that this is a constitutional order. It just boggles my mind. That's the federal district court judge in the check and balance on what the president attempted to do. Yes, it's one, but one of the many orders that are out there now representing the Department of Justice, again, on the other side, inside the Trump Department of Justice, the lawyer for the federal government said the administration's order on birthright citizenship is absolutely constitutional. He argued that undocumented immigrants, get this, remain subject to foreign powers and therefore have no allegiance to the United States, nor the government, argued in the filing, would their American-born children. And that's the basis, using that jurisdictional language in the 14th Amendment, the president attempting to undermine the clear language of the 14th Amendment, a federal district court judge exercising his assigned responsibility, another branch of government, another guardrail, another standard to ensure that the other branch of government does not get out beyond its skis, does not do something that's unconstitutional. The judge entering what is called an injunctive order. It will last for 2 weeks. And then he will have a broader hearing on this. Again, the injunctive order seeking immediate stay on the execution of this particular executive order that would have had huge implications, not just for the understanding of our Constitution, but for legitimate people in the United States of America, including children. We'll talk more about those guardrails, those standards, those applications of our Constitution when it comes to pardon authorities under the Constitution in our second hour as Amicus, a law review, continues.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name's Jim Santelle. Welcome to the second hour of our discussion. Many things to undertake in terms of review and analysis, including this threshold issue of the kinds of things that are present inside our judicial system, our constitutional regime that contemplates checks and balances, and indeed focusing a lot in our first hour on the role of U.S. attorneys, ensuring that the prosecutions, the investigations that precede those prosecutions are legitimate and premised upon a belief that there have been actual violations of federal law, not animated by inappropriate considerations like race or religion, gender identity, those kinds of things, or certainly not politics either. The role also that federal district court judges play in checking the executive, checking even grand jury indictments to ensure that they are legitimate, that they have not been the product of some inappropriate movement forward. And all of that standing in our system, and talking in particular about the role of federal judges in ensuring that the executive branch, whether it's under the rubric of the Department of Justice or any other agency, even the West Wing, is abiding by the Constitution, and in particular noting this important example coming out of the news just this past week, in which a federal district court judge, John Cohenauer in Washington and Seattle, determined, as he said, that this is a blatantly unconstitutional order that Donald Trump has executed, attempting to change the 14th Amendment of our Constitution. Judge Cohenauer, his emphatic decision could not be mistaken. He said, "I've been on the bench for over 4 decades," he said. "This is a blatantly unconstitutional order. Where were the lawyers when this decision was made?" he said, during the course of the 25-minute hearing that he had, in which he decisively said, can't do this. Indeed, Judge Cohenauer was nominated to the bench by Ronald Reagan, again, 4 decades ago, and it is his insight, it is his perspective, non-political, non-partisan. It is regrettable that we talk these days about who nominated you, who confirmed you, what kind of a Senate confirmed you, and whether you're a Republican or a Democratic federal district court judge. The reality is that they take an oath of office to be nonpartisan. And so we hope one day that we can drop those appellations that describe them in a way that suggests that they are partisan. I would offer that Judge Cohenauer this past week is exactly the kind of judge who we need on the bench. And that's the kind of person who, again, provides these checks and balances for, once again, U.S. attorneys and investigative agencies, and yes, grand juries, and yes, the conduct of the executive branch generally. And is there a check upon the judges themselves? The answer is yes. The answer is, of course, as we have already spoken, that they themselves are subject to the advice and consent of the Senate. The Senate has from time to time rejected nominees of presidents based upon the notion that they do not believe that they're qualified to be in those positions. That, too, is a check on them. Plainly, the judges themselves have checks. The appellate process, the Supreme Court process. Even decisions of the Supreme Court can effectively be overruled, if you will, by legislative fixes, for example, in the area of privacy rights and voting rights and many other things, if the Congress decides to do it. All kinds of things in place to ensure checks and balances. And that leads to our callers this weekend. Appreciate very much the contributions to this discussion about checks and balances. I'm going to begin with Mark, who's been in line for a while. Mark, you've got a comment about the legitimacy of this process by which we select federal judges, the importance, I believe, you're going to articulate of this notion that we get people who are competent, who are intelligent, who are bright, whose oath of office means something to them. Mark, glad to have you with me this weekend.
Is this Mark or?
Yes, Mark, go ahead.
Oh yeah. I think the questions have kind of got a little mixed up. I think my first question is on the judicial hires that for the lawyers are going to hire from top-rated colleges. I guess they've suspended that program that then probably we'll be getting lawyers hired from unaccredited institutions to be Trump's new lawyers. But the other question I had, probably more pertinent, and maybe I'm being far-fetched here, but apparently there's members of the Supreme Court that were questioning the legitimacy actually of the 13th, 14th, and 15th Amendments in the first place, maintaining that they weren't properly ratified in the first place, because after all, we forced the Confederacy to sign off on those as part of the conditions of rejoining the Union. And I wonder if that's a attitude they'll take in trying to uphold Trump's birthright citizenship ban. They say, well, the 14th Amendment really isn't legitimate in the first place because it was never properly ratified. I don't know if they'd go to that extreme, but with this group, I do not know.
We don't know, right? And it may well be, again, this order that is unassailable. This is a ridiculous notion. That's not a legal term. That's an observational term that, Mark, you and I and our listeners know well. We learned this in civics, if we've had those classes, and certainly in our general understanding of how government works. This is not a close question. It's unfortunate that our judiciary is taking time to address this plainly unfounded allegation, this unfounded premise that somehow the 14th Amendment should not be understood as its language plainly contemplates. But we know, Mark, as you have just said, that our Supreme Court has surprised us in the past, including invocations of history. We think about the guns cases. We think about Heller and Bruen, looking back in time to find predicates to suggest that what we've thought all along is wrong. Antonin Scalia, back in the time that he reviewed that Heller case, establishing for the first time, based upon history that didn't change, but nonetheless a different interpretation of it, provides now a completely different understanding of the Second Amendment since his time that we had in the long history of our nation until that time. We will see if this particular frivolous and unsupported notion makes its way beyond the district courts, the federal courts in our nation, ultimately the Supreme Court. We shouldn't be spending our time on this kind of thing. Mark, appreciate the comment generally about the legitimacy of judges and where they come from also, as whether it's judges, whether it's lawyers, all those folks, U.S. attorneys who are subject to the advice and consent of the Senate. The questions need to be asked. Are they qualified to serve as judges? Are they qualified to serve in these all-important decisions, making judgment calls based upon the law? That's the role of the United States Senate, and it's appropriate for the public also to weigh in on that process. Mark, thanks for your observation once again this morning. We also have other callers on the line. Ross, calling in. Appreciate your comment or question as a part of our broadcast this weekend.
Hey, good morning, Jim, and thanks for your show. It's just a nice insight into, if I call it an institution, this part of the legal system, which most of us are getting through TV shows or the old Judge Wapner kind of,
yes.
But you're trying to help us understand, and it seems big. I mean, it's a huge issue. But I have like two questions. One specific regarding the pardons.
Yes.
Is whether or not these convicted insurrectionists that have been pardoned, if their records are actually expunged. That is if one of those guys applies for a job at my place,
right.
And I look up their record, am I going to see that? And then number two is just, it seems as if with the way the politics goes, we can, all it can take is one president, Trump, who in the span of his first 4 years can put these members into the Supreme Court. It seems almost as if the law can sort of become, we think of precedent, we think of like, well, this is the way we've always understood it. But I'm wondering if we're now, as I get older and I'm realizing the whole world is just being upended and the things that I thought were normal are no longer normal. I'm just wondering if we're watching or witnessing a legal system where what we thought was precedent is now going to be sort of cast away in some sort of new kind of like, and I know I'm being a bit vague, but when you think of like abortion or you think of immigration, and who knows? I mean, anyway, I won't go on and on, but that was more of a general comment.
Yep.
But that first question is just about if whether or not these guys' records are going to be totally expunged and
Right.
in that respect. Yeah.
Right, exactly. Great questions. And indeed, Ross, that's the next subject on our broadcast this morning, pardons and their implications for those practical kinds of things. I also appreciate very much your second comment about the role of precedent and the notion that Americans should be able to rely again upon the language of their Constitution. We should be able to rely upon the established precedent of 50 years when it comes to privacy rights in this country, of other long-standing traditions, judicial traditions. For example, one that contemplates that federal judges defer to reason, defer to the experts inside agencies. That's Loper Bright Enterprises, which rescinded that concept. It's been out there for 40 years. And while I am sometimes accused of hyperbole, I will not accuse anyone, any caller, including you, Ross, of hyperbole. The reality is the question that you raise about the future and what are the implications when, in fact, the things we understood always to be the bedrocks of our community, of our nation, are no longer that. And again, the pardons themselves, as you identified, also give us pause to think about how that process, which has always in the past, and this is a good introduction into that discussion of pardons, have always in the past been an invocation by a president for mercy. M-E-R-C-Y. The notion has been the reason why pardons are completely unchecked in the Constitution, with some very, very limited possibilities of attack. The reason why they're unassailable is that the notion, James Madison had this thought, you should have a president who looks at the past history. And this does get a little bit to your first question, what this person did, what their crime was, whether they are contrite, whether they've looked back and said, you know what, I regret doing that. I very much come before you, Mr. President, on my knees and begging for some forgiveness and for some sense of mercy. And I've also done something, by the way, in my life that makes sense in terms of making the community better, ensuring that the things that I've done in the past, not only a part of my past, I've taken responsibility for those. I get it. I understand that I can never do those things again, but I've also lived up to higher ideals beyond that. I've done something in my community that makes it better, stronger for my family, for my neighborhood, for my neighbors who are also in need. That's been the application of pardons in the past. And for that reason, getting a bit back to your question, Ross, about the pardon process in particular, there's a thing called the Office of the Pardon Attorney. And most applications, until recently, both our recent presidents have not followed that process completely. We'll talk more, Ross, about your particular question and about pardons in general when Amicus here, a law review, continues. This is Amicus, a law review, talking all about the rule of law in America. Much on our national attention, our national focus, discussions a lot about the processes of government in the wake of this tumultuous and in many ways dizzying week coming out of Washington, D.C. Appreciate very much the inquiry made by Ross just before this last break about pardons, because we're going to talk about the pardons issued by Donald Trump and also issued by Joe Biden before he departed. Ross had a particular question that prompted my reference to the Office of the Pardon Attorney. This is an entity inside the Department of Justice. It's not there in the Constitution. And yes, indeed, whether you are President Trump or President Biden, if you want to wake up in the morning and issue a pardon, you can do it without any process, without any review. But the normal process is that if you make an application, that goes to this thing called the Office of the Pardon Attorney. It's inside the Department of Justice. It's responsible to the Attorney General, and those people look at the merits of an application and they review things. For example, how long has it been? Traditionally 5 years. 5 years after the conclusion of any particular conviction, a judgment, 5 years after the sentence has been served completely. And they also then look at the nature of the underlying conduct, and they look at the things that have happened since the time of the offense conduct, and they make a recommendation to the White House about whether a particular application should be granted or not. That's the normal process in America. Frankly, both Joe Biden and Donald Trump, presumably in recent days, and even the past 10 days to several weeks, have not followed that process. There's nothing wrong with that. There's nothing illegal about it. But the process contemplates some regularity, and that's the reason why it is in place. And so it also prompted Ross to ask the question about the implications of a pardon and what happens when Joe Biden or Donald Trump issues a pardon. And the answer is just this. And again, there's a lot of language here, and I know that this may sound like a lawyer talking because it is, but it's also the standards out that a pardon does not erase a conviction. Plainly, it doesn't erase a conviction from history. We're going to talk in just a few moments from now about the words of federal district court judges who are affirming just that even though the pardons effectively dismiss cases, they do not erase things from history. They do not erase a conviction in the official records, but it can restore civil rights and remove some legal disabilities that are out there. Pardon, again, a form of forgiveness, an extension of mercy by the president, restoring civil rights, those kinds of things. It can relieve some of those long-standing legal disabilities. It does not remove, in response to Ross's question, a conviction from public view. And so if those folks come forward, they will say, you know what, I have been forgiven. My pardon effectively removes officially any of the impediments, should be, to all those other civil liberties out there. But it is still there as a part of the public view that can be accessed. It can also include sealing records related to the conviction in some states. And to remove a conviction from a person's record, then you have to go through the second process, which some of them have also done, called expungement from the court record. So it's a little bit deep. There's a lot going on there, but the answer is ultimately that expungement seals that person's record so that the conviction is no longer publicly accessible. Pardon in itself accomplishes a lot of things, but does not prevent public view of what happened here. We also have other callers on the line. Again, appreciate both Mark and Ross to this point, and also appreciate John, who's likewise been waiting for a long time to be a part of our discussion this weekend on Amicus. John, go ahead with your comment or your question.
This is Jack from Merrimack.
Yes, Jack, go ahead.
Okay, I have two comments and a question.
All right.
The first comment is this is what you get when you put a criminal into the White House. Is he will pardon other criminals. That's that's part of his duty. Second thing I want to say is apparently the Supreme Court of the United States has implemented what I'm going to call the Nixon doctrine. I believe it was Nixon who said, If the president does it,
Oh,
it's
yes.
illegal.
Right. I'm
And
very famous, a
that's-
very famous interview, right, with David Frost, right? And all of us rejected that and said, no, he's wrong about that. Turns out, Jack, I suspect this is your comment, that the Supreme Court said, yeah, in terms of that Trump versus United States case in July of this past year, they said, turns out Richard Nixon was right. Go ahead with your further exposition of that, please.
Okay, well, the question that I have then is this. Okay, so Trump has royal immunity. He can't be prosecuted for virtually anything he does, including inciting insurrection in office, by the way. But I'm not. That's not what I'm going to go. I am going to ask this though. He can order all this stuff done. For instance, he can order the unlawful arrest of American citizens who are either naturalized citizens and just, either don't have their papers on them, things like that. I believe stuff like that's already happened, by the way. But what about the people who are actually responsible, who are physically doing that? Can't they be prosecuted for illegal activities? That's the question.
Right.
If you order something illegal, let those people who do it, who implement it, because he's got a whole bunch of lackeys and yes men around him. Can't those lackeys and yes men be prosecuted? Of course, he could probably give a pardon to them preemptively too, but it still could cause them to at least have a little pause.
Right, absolutely. And Jack, that is the question of the days and the hours here, right? In the wake of the Supreme Court's decision, as you accurately noted, not only establishing a hugely powerful executive branch, but also saying you're immune from prosecution. The case coming out of the Supreme Court on July 1 talks about the president himself or herself, does not talk about that all-important question about what happens when the president directs somebody else, including people in the Department of Justice, including an attorney general, including an assistant attorney general, including a United States attorney, to do something. Are they also protected by virtue of an umbrella or shield of this immunity? That hasn't been tested. And again, it goes back to this notion that I was articulating earlier in response to previous comments and questions and observations, which is this is the reason why you need to have people as U.S. attorneys, as an attorney general, as, frankly, supervisors, special agents in charge of the FBI. This is the reason why the director of the FBI and his subordinates. This is the reason why people are in charge of the ATF and DEA and other federal agencies in all of our districts nationwide need to be people of integrity who say that their ultimate obligation is not to a president. It is to the Constitution. It's to the people of the United States of America. And if indeed they're being asked to do something that they have concluded is not only violative of legislation, of laws, but of the Constitution, their oath compels them to say no. And that's the tension that we may, in fact, be seeing in the near future here, especially as the Department of Justice recently, again, issues a memorandum suggesting that people in state and local authorities could be prosecuted for exercising their sense of what is right and wrong in America. Jack, appreciate the comment very much. All of that going to be coming up in terms of assessments of the future of America. We'll do exactly the same thing as Amicus Law Review continues. to Law Review. My name is Jim Santelle for these remaining minutes in our weekend broadcast about all things legal and rule of law, justice related as well. Spending some time necessarily talking about pardons in America. Once again, an issue that we have visited in past broadcasts. A couple of things, again, in the category of basic civics. We know well Article 2, Section 2, Clause 1 of the Constitution says this: President shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. An interesting condition there at the end of that. And that's all the Constitution says about pardons. It is an unfettered, unchecked authority of the presidency. And indeed, the United States Supreme Court, in some collateral review of issues related to that, have said just that in a case called Ex parte Garland. Not our president or our former U.S. Attorney General, back in 1866, said the power conferred is unlimited, with the exception of the impeachment aspect. The power of the president is not subject to legislative control. Congress can neither limit the effect of the pardon nor exclude from its exercise any class of offenders. The benign prerogative of mercy, once again, that mercy concept reposed in him cannot be fettered by any legislative restrictions. That's Ex parte Garland. A couple of other things that are important to understand in addition to this unchecked authority of a President Biden, of a President Trump to issue these pardons is just this: that pardons, in fact, can be rejected. A case called Wilson, 1833, Supreme Court held that a pardon can be rejected by the intended recipient and must be affirmatively accepted by that recipient to be recognized by the courts. And indeed, you know well, there's at least one, if not more, of the so-called recipients of the pardon from Donald Trump who said, no, I do not accept it. I have done something wrong, and I do not want to be a part, one particular defendant said, of a cult. I have rejected what I did before. I recognize that what I did was wrong, but I don't want that pardon. I want my record to remain because of what I did and stand as a symbol, a deterrent to other people. Supreme Court says you can do just that. There's also a thing called commutation, which we also saw from Donald Trump just this past week. He commuted the sentences of many of the organizers, the Proud Boys, the Oath Keepers, the Enrique Tarrios, the Stuart Rhodes of the world, reduced their sentences from these long, decades-long sentences to time served, and they were released. That's reducing the sentences. That's not issuing pardons, although he did some of that as well. And in that case, you cannot refuse a commutation of a sentence different from a pardon. And here's the other big point that I've also underscored implicit in those Supreme Court cases. And it comes from a case called Verdict and says just this: Supreme Court telling us that the acceptance of a pardon is an imputation of guilt, an acceptance of a confession of it. In other words, you take a pardon, you accept a pardon, and you're acknowledging that you have done something wrong. That's Burdick versus United States in 1915. Circumstances, the court said, may be made to bring innocence under the penalties of law. If so brought, escape by confession of guilt implied in the acceptance of a pardon may be rejected. And that is an important notion, not only for what has happened here in terms of the Trump pardons, that is all of these 1,500, 1,600 people pardoned by Donald Trump, carrying along with it, even though much debate, appropriate debate, about the propriety of releasing violent criminals back into our communities, also carrying with it the legal imprimatur of an acceptance of guilt for what they were convicted of. That's no small matter. And it also animates, of course, the preemptive pardons that were issued by the prior president, Joe Biden. Much discussed. The prior pardons also carry with them a recognition that there's something wrong. And that's my principal argument, candidly, with the Biden preemptive pardons. That is that the people, good people, decent people, did nothing wrong. Nothing wrong at all. They did not commit crimes, unlike the Trump pardons. And yet the acceptance of those pardons, which, yes, indeed, shields them from the investigations we talked about before, shields them from the prosecutions that Donald Trump has promised. And I get completely the concern about that legitimate people might be subject to investigative work, arguably prosecution work, if in fact the systems fail us, Even so, I am concerned profoundly that those pardons also carry with it admissions of guilt. Tony Fauci did nothing wrong. Tony Fauci was a public servant, and there's nothing about his background that was criminal in nature. Mark Milley, likewise, nothing wrong at all, served with great honor, did not commit a crime. The pardons that they and others accepted, including the pardons of the Biden family, carry with it the legal imprimatur of having done something wrong, and that's my concern for the present and also for the future here. What should have happened in all these cases is that attorneys, frankly, looking again to attorneys, should step up and say, when those investigations happen under this present administration, attorneys agreeing to represent the targets of those investigations in those investigative pushbacks. That's what should happen. The lawyers of this country concerned about decency in the investigative process should step up and offer in a pro bono way to serve those people who are unlawfully, inappropriately, unconstitutionally targeted, as opposed to pardons. And yet, once again, all those pardons now in place by virtue of the absolute unchecked capacity of a Joe Biden and of a Donald Trump to impose those pardons. And the other comment I make before we get back to some other callers is just this. The pardons by Donald Trump, wildly different from the pardons granted by Joe Biden. Joe Biden exercising mercy in every single one of those pardons recently, and yes, in the 1,500 group, in the 2,500 group, all of them consistent with the purposes that the Office of the Pardon Attorney probably put on the imprimatur on those pardons. He was acting consistent with the mercy contemplated by our founding fathers. Donald Trump, in granting these pardons to 1,500, 1,600 people, what did he do? What was his approach to all of this? Well, over 600 of them violent criminals, we know. 600 people. Of that, a great majority of them engaged in violent activities and violent conduct on January 6th of the highest element. And as we said earlier, the result of all of this, in response to Ross's very good question, is their privileges and immunities are now restored. And that includes those pardons carried with them, the right now to carry weapons. There's a federal law, as you well know, that says that if you're a convicted felon, you cannot carry a weapon in America. The pardons basically remove that restriction. And now these 1,500, 1,600 people, some of them the subject of commutations, many of them violent criminals, the subject of those pardons, now able to carry weapons as well. Let's get back to some of our callers calling into our broadcast. Dick from Madison, appreciate your being a part of our discussion this weekend.
Well, you answered one of my questions.
All right, very good.
Attorneys taking pro bono, because I feel this guy that was arrested or detained in Newark should not have to spend money out of pocket. Anyway, question is this. When did the Oklahoma bombing was about 94?
Dick, you pitched out just a little bit. Can you repeat what you just said?
The Oklahoma bombing in 94, I believe it was. If we would have put on the books domestic terrorism laws, would he have been able to pardon them then? I mean, something that would really stick.
Right. Obviously, this is Timothy McVeigh and Terry and Nichols way back then. And as you know, Timothy McVeigh, one of the folks who gets the death penalty. It is available in the federal system, as we know. It's not in violation of the Eighth Amendment. And Timothy McVeigh executed for that horrific event during the Clinton administration for what happened at the Murrah Federal Building there in Oklahoma City. Hundreds of people, including many children, killed at that time. The answer is, to your very good question, Dick, the pardon authority spreads to all federal offenses. So if the United States Congress issues laws and executes, and the Department of Justice executes on those laws, if they are federal convictions, federal judgments, a president can pardon, can also commute sentences imposed under those. So the nature of the underlying offense conduct, the way that the Congress describes it, is less important than the fact that they're federal. And your question, though, Dick, raises a very good point, which is federal pardons, the federal pardons that the presidents, Biden and Trump, have recently issued, do not extend to state offenses. And maybe that's where you go, Dick, right? You go to the state legislatures, which can also and do impose here in Wisconsin, in every other state and territory in the United States, they also issue and they also legislate in the criminal area, and they say this is prohibited. And if you engage in this conduct, whether it is of a terrorist nature, whether it is a domestic violence, white collar offenses, federal offenses, financial offenses, document cases, all kinds of things, states can also make crimes in violation of their laws. Donald Trump was convicted of one set of those kinds of things. He stands a convicted felon in the state of New York. And for that reason, a president unable to effect a federal pardon on someone in that condition. We'll continue with this as we continue with our discussion here on Amicus, a law review. And in that connection, we have Richard on the phone. And Richard, your comment and your question here.
Okay, if I'm wrong, correct me. But in the 1920s, when Al Capone was out on the streets, from what I understand, a group of private businessmen, individuals, funded a research on him. Is that possible? If it's so, in this case, of at least the participants in some of this stuff going on.
Richard, I have to confess to you, I do not.
Take their licenses away.
Right, yeah. I'm not familiar with that particular history regarding Al Capone. Plainly prosecuted again by the government and found guilty ultimately, and went to jail for tax offenses. Right. And
I understood that there was like 8 or 9 private business individuals that funded up the work.
I am not familiar with that history, but it's interesting to think about.
Oh.
Again, go ahead.
No, well, it the public was getting so upset over it, and at the time, I think Delano Roosevelt said, "Why is he still on the street? He's wandering around Chicago."
Sure. And there's no doubt that regardless of what may have been done privately, obviously the country plainly very concerned, both outside and inside government, about what was going on with Al Capone, those kinds of things. Government continues to focus on white collar offenses and those kinds of things, mob kinds of things, all kinds of federal statutes that prohibit the things that Al Capone was doing. Regardless of the history, that I'll trust you, Richard, in terms of your description of some private initiatives to investigate him. Undeniably, the government itself was also investigating him, and there's no way in which the prosecution of him for tax offenses could have gone forward without again the IRS and U.S. attorneys, Department of Justice, and others pursuing those internal government processes to address the Al Capone situation. But again, underscores the broader point, Richard, which is Americans should be focused upon what a Department of Justice does, both to ensure the safety and security of the community, and also to ensure that the processes of the Department of Justice, access to a grand jury, all the other things we talked about with respect to courts, that none of that is used in an abusive way. All of that has got to be the product of an integrity-based system where you've got good U.S. attorneys in place who understand their roles. You've got good federal judges, good grand jurors, all of them a part of the system. When we come back, some final observations about pardons and the rule of law in America. This is Amicus Law Review. Appreciate tremendously the wonderful comments, the insights, the questions asked by our callers always on our weekend broadcast. Invite you to this discussion. Thank you so much for those contributions. The several of you have called in. You can also text in, of course, and get my attention and Max's attention as well as we discuss these various issues. Plainly, we will not be getting to, in substance, to some of the other important events of this week, including things inside the Department of Justice having to do with this directive to investigate and prosecute state and locals who may be opposed to the president's immigration policies, the implications for the Civil Rights Division of shutdowns, no new cases, no new movement forward on consent decrees, and also some Supreme Court issues having to do with, again, the future of law enforcement in America and even on money laundering offenses. All of those things we're going to talk about in greater detail. They'll remain current in our next broadcast, so stay tuned for those as well. In our remaining minutes of this broadcast, however, let us continue to discuss this notion of pardons in both categories, both the Biden pardons, which again I've described in terms of an invocation of mercy, raise some concerns about the precedent that is set when a president issues preemptive pardons. And I have a colleague out there who says he's looking at all this and seeing the death of the pardon authority under the Constitution. I may not go that far, but it raises concerns about the precedent set. As one president leaves office, are we at the end of every term now going to be issuing preemptive pardons for anyone who served in the prior administration? That is not in the interest of the rule of law. That is not in the interest of justice overall. And again, my recommendation for all of that, if there are those people who are inappropriately politically, based upon partisan views, identified and targeted by an inappropriate administration, by an inappropriate attorney general, by an inappropriate U.S. attorney who's violating their integrity, their oath of office. What has to happen in America? Attorneys have got to come forward and offer for people who do not have a lot of resources. When you work for the government, you're not going to make a lot of money. You're not going to become multimillionaires. Attorneys in our nation, including me, need to come forward and say, I will represent you in the course of those investigations to ensure that you get the proper authority, that there is pushback on those investigations when and if they are products of those partisan authorities. That's the remedy to this problem. And going back once again to my greater concern and my much stronger condemnation of the pardons issued by Donald Trump. Once again, these are people, just to be clear, who engaged in the worst kind of violence possible. I think the media is doing a wonderful job these days of identifying not only the particular individuals, the subject of these pardons, but the violent people who are a part of these pardons. 608 of them altogether charged with assaulting or impeding federal officers. Of that group, 174 charged with enhanced versions of the law for crimes involving deadly or dangerous weapons, inflicting bodily harm on the officer. Indeed, we know the stories of those events. The video remains chilling as much today as it did in the immediate aftermath of January 6th. The wiping the slate clean for violent offenders who did what? Using batons and stun guns and flagpoles and tasers and baseball bats and 2x4s and bear spray and chemical spray to attack our law enforcement officers. 5 of them died, Mr. President, and others injured. A horrific event in American history, and you have given them all pardons. You have forgiven through this process their horrific conduct. And the justification that you provided to that is they've been in jail for a long time. President Trump said these people have been destroyed. The victims of January 6th have been destroyed beyond words. And the condemnation that I convey on this broadcast in response to these pardons cannot be overstated. This is not the reason why James Madison put the pardon authority in place in our Constitution. plainly not a product of the deliberative process that our Vice President, J.D. Vance, contemplated when he said these were reviewed on a case-by-case basis. And indeed, as did many members of Congress, said that the violent criminals, those people who were that 608 group, they will not be pardoned. Plainly, that did not happen. The process by which assessments of the legitimacy of these pardons never went through the Office of the Pardon Attorney. That we're clear on. And that also underscores the great concern that all Americans should have for the conduct of this president in undermining the rule of law in this very significant way. In that connection, this president also did something else this past week that we will close on in this segment of our broadcast, and that is he requested that the pending investigations against remaining targets and defendants of January 6th, that those also be dismissed. And a number of judges in the federal courts there in D.C., 3 in particular, District Judge Beryl Howell, District Judge Tanya Chutkan, and District Judge Colleen Collar-Catelli, all decided, yes, indeed, I will dismiss those cases upon leave of court, which is the standard by which the rule is invoked to get those cases dismissed. But they also said, I'm not granting you everything that Department of Justice is asking for. I'm not going to grant that these dismissals will be with prejudice, which means they can never be brought again. They're going to be dismissed without prejudice. And even more important than that concept, they also spoke about the implications of what they were doing. Here is Beryl Howell saying, contrary, Mr. President, to what you said, no national injustice occurred here, just as no outcome determinative election fraud occurred in the 2020 presidential election. No process of national reconciliation, she said, can begin when poor losers whose preferred candidate loses an election are glorified for disrupting a constitutionally mandated proceeding in Congress and doing so with impunity. She goes on to talk about the dangerous specter of future lawless conduct by other poor losers and undermining the rule of law. Judge Tanya Chutkan, also presiding over these cases, what does she say? She says that Trump's mass pardons cannot whitewash the blood, the feces, and the terror that the mob left in its wake. It cannot repair, she said, the jagged breach in America's sacred tradition of peacefully transitioning power. In hundreds of cases like this, she said, judges in this district have administered justice without fear or favor. The historical record established by those proceedings must stand unmoved by political winds as a testament and as a warning. All of that coming out from federal judges, other checks and balances in America under our Constitution. Thank you for joining me for this edition of Amicus, a law review, every single weekend here on the broadcast stations of Civic Media. Have a good weekend, everybody.